he left me when I refused to end my pregnancy. 5 years later, he saw my twins at a mall and his mother's $2 million life finally came crashing down. The morning everything unraveled, I was crouched on the floor of the riverside, mall tying a dinosaur sneaker. Eli's left lace had come undone for the third time since the parking garage, which meant either the bow was defective or 5-year-olds were structurally incompatible with double knots, and I was betting on the second one. Beside me, Noah had his chin on my shoulder and was whispering something about weather. The pretzel face was still near the fountain, his breath warm against my ear, and I was laughing, really laughing, the kind that lives in your chest and comes out before you decide to let it. When I looked up and the laughter stopped, he was standing 40 feet away next to a marble planter with a coffee cup in his hand, and he was looking at my sons the way people look at things they cannot yet fully explain to themselves, with a stillness that was almost physical, like his whole body had forgotten what it was doing in the middle of doing it. Julian Vale, 5 years. He hadn't changed enough. That was the thing that hit me first. She hadn't changed enough, and I had changed completely. And somehow the distance between those two facts was the most clarifying thing I had felt in years. My hands closed around both boys before I made the decision to move them. Reflex. 5 years of building a life, of learning to trust that we were safe, of teaching myself that his absence was not a wound, but a weather pattern, something you adapted to, something that shaped the landscape without destroying it, and it closed around them in one heart. Noah felt it. He always felt things first. Mom, he looked up at me. Do you know him? Julian stepped forward. Mara, my name in his voice. After 5 years of silence, I stood up. No one important, I said. I turned the boys away toward the pretzel place, toward the fountain, toward the ordinary Saturday morning I had planned and earned and intended to have. He stepped forward again. Are they mine? I stopped. I turned around slowly, and I looked at Julian Vale, this man who had once held me at 3 o'clock in the morning when I couldn't sleep, who had laughed at my bad jokes in conference rooms, who had looked at a pregnancy test wrapped in tissue paper and handed me an envelope. And I felt something that was not anger. Exactly. Anger had been the first year. What I felt now was older than anger. Cleaner. No, I said they're mine. What? I did not say, standing in that mall with my sons looking up between us, and Julian's face doing something complicated and unguarded in public for possibly the first time in his adult life, was that I had questions. I had questions I didn't know I needed to ask. Yet, that part would come later. First, I took my boys for pretzels. Let me take you back, because this story doesn't start in a mall. It starts in a conference room on the 31st floor of the Vale Group building in the fall of 7 years ago, when I was 27 years old and had been working as junior legal counsel for 11 months and had spent every one of those months doing the thing I always did, working harder than the job description required and refusing to tell anyone that the answers I handed back were better than the ones I was handed. My name is Mara Bennett. I grew up in Columbus, Ohio, went to Ohio State on a full academic scholarship, went to law school at Georgetown on borrowed money and sheer stubbornness, and landed at Vale Group because their general counsel had read a paper I published on derivative liability frameworks and called me directly, which had never happened to me before, and which I took as a sign. It was a sign, just not the one I thought. Julian Vale was at the time 34 years old, the CEO of a Real estate and development firm his grandfather had built and his father had nearly destroyed, and he had spent a decade resurrecting. He was charming in the way that people are charming when they're actually intelligent, not performed, not calculated, just there, like a frequency you catch if you're standing in the right place. I was standing in the right place. I want to be careful here because I'm not interested in making this a love story. It was a love story briefly, but that's not what it's about. What it's about is what happened when the love story ended and what I chose to do instead of disappearing. We were careful at first, then less careful, then somewhere in the spring, not careful at all. And then on a Tuesday morning in early summer, I stood in the single occupancy bathroom on the 31st floor with a pregnancy test in my hand, and I felt two things simultaneously: the specific terror of a situation with no clean resolution, and underneath it something quieter and more certain that I already knew what I was going to do. I went to Julian's conference room because I thought I owed him the truth in person. I thought the man who had held me at 3 a.m. when I couldn't sleep might show up. Instead, he turned toward the window. He talked about his board, his family name, his mother's expectations, the way a pregnancy would look at this stage of the company's public perception, which was a sentence I still cannot fully believe a person said to me in earnest. A baby is not a scandal. I said, for you, maybe not. He slid the envelope across the table. I looked at it. Money, a clinic appointment card, a lawyer's name on a card, a neat set of solutions for an inconvenient situation organized by someone who was very good at solving problems and had decided in this case that I was one. I came here, I said, because I thought the man who held me at 3 a.m. might show up. Instead, you brought documents. I pushed the envelope back against his chest and I walked out. 3 days later, I resigned. I moved back to Columbus into my Aunt Clara's spare room and I rebuilt everything from scratch. New city, new firm, small, enough that I could take on cases I believed in and large enough to make rent. I built a practice around tenant rights and employment discrimination, which suited my particular combination of skills and stubbornness and the specific fury of someone who has been handed an envelope when they expected a conversation. I had the boys in February, Noah first, then Eli 11. Minutes apart, Eli came out screaming like he had opinions about the experience. Noah came out quiet, looking around the room with an expression that reminded me later of a person taking notes. I named them and I raised them. And I did not for 5 years hear a single word from Julian Vale. That was what I thought. That was not what had happened. The call came 3 days after the mall. I was at my desk at Bennett Legal Group. My firm, 6 years old, 7 attorneys, 2 paralegals, and a caseload that would have been impossible except that I had built a team of people who were to a person constitutionally unable to back down from things that mattered. It was a Tuesday afternoon, and I was reviewing a motion in Lemonade when my phone rang from a number I didn't recognize. I almost didn't answer. I answered, Miss Bennett. The voice was controlled, measured, the voice of someone trained to deliver information without coloring it. My name is Daniel Hole. I'm an attorney at Calder Hole and Reyes in New York. I represent Julian Vale in a personal matter. I'd like to speak with you about an NDA executed in your name approximately 5 years ago. The room did not change. My desk did not change. My coffee was the same temperature it had been 10 seconds ago. I said, I don't know what you're talking about. A Pause. Miss Bennett, are you aware of a settlement agreement sent to your Columbus apartment in the fall, approximately 1 week after you resigned? From Vale Group, I never received a settlement agreement. A longer pause. Miss Bennett, Daniel Hull said carefully, I believe you, and I think you need to. Hear what we found. I drove to New York the following Thursday, not because I had to. Holt had offered video conference twice, but because there are conversations you need to be in a room for. Conversations where you need to be able to read the documents with your own eyes and feel the weight of the paper in your hands. Calderhole and Reyes occupied 3 floors of a building on Park Avenue. Daniel Hull was 48 years old, silver-haired, with the specific manner of a senior attorney who has seen enough to be almost impossible to surprise and who responds to the things that do surprise him with an unusual quietness. He met me at the elevator. In the conference room, he opened a file folder and placed 3 documents in front of me. The first was a settlement agreement, $2 million, an NDA covering the entirety of my relationship with Julian Vale, the pregnancy, and my departure from the firm. Standard legal language, except for the clause I found on page 7, which specified that I agreed to make no contact with Julian Vale, his family, or any representative of Vale Group, and to take no legal action regarding paternity or support. My name was on the signature line. I had never signed this document. I had never seen this document. I had never received $2 million. My hands were very still. I noticed that specifically that my hands were still while my chest was doing something complicated and pressured. The signature, I said, yes, laced a second document beside the first of forensic handwriting analysis prepared by Dr. Sandra O's 20 years in question document. Examination formerly of the FBI's Forensic Document Laboratory. Dr. Ice's report concludes that the signature on the settlement agreement is not consistent with Julian Vale's known signature samples across 422 authentic documents. The ink composition and pen pressure are inconsistent. The letter formation in 3 specific characters differs from every verified Vale signature in our possession. Julian didn't sign it, I said. No, someone signed his name. Yes. I looked at the 3rd document, an internal wire transfer authorization dated 1 week after the settlement was executed, moving $2 million from a Vale Group subsidiary account to an account registered to a law firm I had never heard of, Pratt & Connolly, since dissolved, which Holt's investigators had traced to an attorney who had worked exclusively with one client for a period of 18 months before the firm shuttered. Margaret Vale, Julian's mother. I sat with that for a moment. Margaret Vale, 67 years old, former chairwoman of the Vale Group Board, a woman I had met exactly once briefly at a company event, where she had looked at me the way certain women look at certain other women when they have made a swift and complete assessment and found the result unsatisfactory. She had been pleasant, professional, the pleasantness of someone who does not consider you a threat because they do not consider you at all. She had forged her son's signature. She had sent me a settlement I never received, with money I never got, for a silence I had technically agreed to without knowing it. And for 5 years, Julian had believed I had taken the money and signed the agreement and deliberately kept his children from him. He thought I chose this, I said. Holt was quiet for a moment. Yes, until the mall. The mall. He hired a document examiner the day after he saw you. He'd been carrying questions about your departure for years, Ms. Bennett, but he had the signed NDA and he believed what the document said. When he saw your sons, he went back to the file. He found the inconsistencies. I looked at my hands. $2 million sent somewhere to a firm that dissolved to an attorney who worked exclusively for Margaret Vale and then apparently found employment elsewhere and did not leave a forwarding address. I thought about 5 years of my Aunt Clara's spare room, 5 years of rebuilding from scratch, 5 years of raising 2 boys on a junior attorney's salary, and then gradually on a practice. I had built case by case. I thought about the money for my son's health insurance, which I had spent 6 months fighting with the state marketplace to get right. Throughout the year, Noah needed speech therapy, and I had worked Saturday mornings for 4 months to cover the copays. $2 million sent somewhere. That was not to me. I said, what does Julian want? Holt said he wants to meet with you without attorneys if you're willing. He wants to tell you himself what he found, and he wants you to know. Paused in the way of someone choosing words with care that he understands if you never speak to him again. He wants you to have the information regardless. I thought about it for a long time. Tell him Thursday, I said. Coffee public place. I'll bring my own attorney and she'll wait outside. My attorney was Patricia Owens, JD, 30 years in family law, formerly of the Ohio State Bar Association's Ethics Committee, currently a named partner at a firm that occupied 2 floors of a building in downtown Columbus and had more Martindale Hubble ratings than I had. Time to count. She was 61 years old, wore reading glasses on a beaded chain, and had the specific quality of someone who has represented enough people in enough difficult situations to have arrived at a complete and unsentimental understanding of human nature. I had called her the night I got back from New York. Walk me through it again, she said. From the beginning, I walked her through it. She was quiet for a long time after. The NDA is unenforceable, she said. Finally, you didn't sign it. You never received consideration. The $2 million never reached you. A contract requires offer, acceptance, and consideration. You accepted nothing. You received nothing. The NDA is void. That's what Holt said. Holt is right. She paused. Mara, the forged signature is a separate matter. That's fraud. Potentially wire fraud given the transfer. That's a federal issue. I know. What do you want to do? What did I want to do? I thought about my boys in their dinosaur backpacks. I thought about Noah's gray eyes looking up at Julian in the mall with the specific curious openness of a child who has not yet learned to be guarded. I thought about 5 years of building something real and solid from nothing, and I thought about what it meant to find out at the end of those 5 years that the nothing had been manufactured. I want the truth to be documented. I said formally, publicly, if necessary. I want my sons to be able to know when they're old enough exactly what happened and who made which choices. And I want Patricia, I paused. I want whoever has $2 million that was moved in my name to answer for where it went. Patricia was quiet. Okay, she said. Then let's start with what we can prove. The meeting with Julian was at a coffee shop in Midtown, the kind of place busy enough to be anonymous and small enough that a conversation at the corner table was unlikely to be overheard. He was already there when I arrived. He looked like a man who had not slept in 8 days, which I later learned was accurate. I sat down. He pushed a folder across the table. I recognized the documents. Dr. Sorter, OC's handwriting analysis, the wire transfer records, the Pratton Connolly registration documents. I had my own copies I let him explain them anyway, because he needed to, and because watching him explain them told me things that the documents couldn't. He was not performing. That was the thing. Julian Vale, in my experience, was someone who had learned to perform well in high-stakes situations, to manage effect, to control the impression he made, to present exactly the version of himself that the room required. That skill had been, I think, a significant part of what made him good at his job and impossible to fully know. The man across the table from me was not performing. He was just there, wrecked and there. I thought you chose it, he said. The settlement. I thought you signed it and took the money. And he stopped. I told myself it was what you wanted. I told myself that was why you told yourself what was convenient. I said. He didn't argue. You didn't try to find out. I said for 5 years. No, he looked at his hands. I didn't. Why? A long pause, because trying to find out would have meant admitting that I had behaved in a way that I couldn't defend. And I had spent 5 years telling myself that the envelope was that I was protecting you, that it was a reasonable option to present. He looked up. I was wrong about almost everything that year. I thought about the envelope, the clinic, appointment card, the lawyer's name, you, where I said, I know I'm not Julian. I'm not here to forgive you or not forgive you. I'm here because my sons deserve to know the truth about what happened. And the truth involves decisions that were made before they existed, and I want them on record. He nodded once. Whatever you need, whatever Patricia needs, I'll provide everything. And your mother, his jaw tightened. I've spoken to my attorney about that. There's going to be a formal process. Good. I picked up my coffee. I want you to know something. I want you to understand it completely. I looked at him directly. I did not suffer because of your mother. I suffered because of the envelope. What your mother did made the suffering longer, and she stole something from my sons that I am still curious about. But the moment that set all of this in motion was you in a conference room reaching into your jacket. He looked like that had cost him something. I know, he said, your mother gave you a way to believe it wasn't your fault. She robbed you of the consequence. And she robbed my boys of 5 years. I sat down the coffee. I don't know what you do with that. That's between you and whatever accounting you make of your own life. But I needed you to hear it. He heard it. I could tell he heard it because he didn't try to answer it. And sometimes the right response to a thing is just to let it land. The formal investigation moved on 2 tracks. Simultaneously, Patricia filed for a declaration of NDA invalidity in the New York court, a clean procedural matter, given that I had never signed the document and never received consideration, and that Dr. Oa's forensic analysis was, in Patricia's words, as airtight as document evidence gets. She also filed for formal establishment of paternity and child support, which Julian did not contest, and which his attorneys had apparently already prepared paperwork to facilitate. The second track was federal. Daniel Holt, working with an investigator named Ray Castillo, 22 years in white-collar financial fraud, former assistant U.S. attorney for the Southern District of New York, had spent 3 weeks tracing the $2 million wire transfer. The Pratt and Connolly firm had dissolved in the spring following the transfer. 6 months after its formation, the attorney of record, one Gerald Pratt, had subsequently worked as private counsel for several clients connected to the Vale family's charitable foundation before retiring to Florida in 2021. The $2 million had moved twice after reaching Pratt and Connolly, The first transfer, Castillo, found had gone to a holding account under Margaret Vale's personal trust. The second, executed 6 weeks later, had gone to a renovation account for the Vale family's estate in Greenwich, Connecticut. She had used it to redo the kitchen. I sat with that for a long time. $2 million in my name that I had never received, used to renovate a kitchen in Greenwich while I worked Saturday mornings to pay for my son's speech therapy copays. The forensic trail was clean, almost too clean. The kind of clean that comes from someone who was confident they would never be examined. Ray Castillo presented his findings to the U.S. Attorney's Office on a Wednesday morning in November. The charges filed against Margaret Vale included wire fraud, document fraud, and misappropriation of funds. Federal charges, serious and specific, the kind that come with consequences regardless of the family name attached. Julian was not charged. His signature had been forged without his knowledge, and Castillo's investigation found no evidence of his involvement. Margaret's attorney, a man named Lawrence Breitheit, who had represented the Vale family for 30 years and who looked when I saw him briefly in the hallway outside the U.S. Attorney's Office like a man who had been handed a set of acts he wished he'd been given earlier, entered a not guilty plea at arraignment and requested a trial date. The trial didn't happen 6 weeks into the discovery process, with Dr. Osa's forensic analysis entered into the record and Ray Castillo's financial trace documented in 37 exhibits. Margaret Vale's attorneys reached out to the prosecutor's office. She pleaded guilty. Wire fraud, 1 count. The other charges were reduced in exchange for the Lee and a financial judgment that included, among other things, restitution to Mara Bennett in the amount of $2 million less interest. I was in Patricia's office when she called me with the news. I sat there for a moment with a phone in my hand. Mara? Patricia said, "You there?" "Yes," I said. "I'm here. How do you feel?" I thought about it honestly. "Tired," I said, "and okay, both at once." "That's about right," she said. The restitution took 4 months to process. Patricia managed it. I mostly stayed out of the way and let her do what she was very good at doing. Julian and I had reached a parenting agreement through attorneys, civil specifics structured the way these things need to be when the people involved have a complicated history and 2 5-year-olds who deserve clarity. He was granted regular visitation, starting slowly and building over time. The first visit was a Saturday afternoon at a park, with both attorneys present, which sounds clinical, and which was also the day I watched Eli grab Julian's hand to show him something he'd found under a rock, which was not clinical at all. Noah was more careful. Noah is always more careful. He spent the first 3 visits observing Julian with the specific assessing quiet of a child who is learned very early to determine whether a person is trustworthy before he decides to be warm. It took until the 4th visit, when Julian sat on the grass for 45 minutes and let Noah explain in complete and serious detail the plot of a dinosaur book he was reading. After that, Noah talked to him a little more. "I'm not telling you this was a happy ending in the clean wrapped way that phrase implies. It wasn't. It was a real ending, which means it was complicated and ongoing and not finished. My sons have a father now. He is working visibly and imperfectly to deserve that. Whether he fully gets there is a question I have stopped trying to answer in advance. What I know is this: I did not disappear. I was supposed to disappear, handed an envelope and pointed toward a door and expected to understand that the message was, "You are not the kind of thing that lasts in this world." And I had walked out of that conference room and built a life anyway, piece by piece, on my own terms, without the $2 million that had been stolen from me in my name. I built it anyway. That is the part that belongs to me. That part nobody forged. The last time I saw Margaret Vale was in the hallway outside the federal courtroom on the day she entered her lead. She looked older, smaller, not diminished exactly. She was still a woman who carried herself as though the room were built around her, but there was something missing from it. A certainty, maybe. The specific, unquestioned confidence of someone who has spent 7 decades being insulated from consequence by money and position and the social agreement that people like her simply do not face these particular rooms. She was facing this particular room. She looked at me. I did not look away. She said nothing. Neither did I. There was nothing to say that the documents hadn't already said more cleanly.